And thanks for joining. My name is Kelsey Atkinson, and I am a staff attorney with the Legal Aid Foundation of Los Angeles. And I'll be presenting today's workshop on tenants' rights and small claims court. So there are two main goals to this presentation. First is to help you understand your rights as a tenant, and second is to understand how you can utilize small claims court to potentially sue your landlord for violation of your tenant's rights. So with those goals in mind, our presentation breaks down into two distinct parts. First, we're going to do a high-level overview of some of your tenants' rights. And then in the second part of the presentation, we'll talk about how to sue in small claims court when your tenants' rights have been violated. Before we get into the small claims content for today, I just want to point out that we will not be discussing any of the eviction protections or the eviction process in this presentation. If you're looking for more information on those topics, I encourage you to check out Stay Housed LA. Their website is stayhousedla.org. And on their website, you can submit a request for legal assistance and you can sign up for additional workshops and presentations on topics relating to eviction. So now we'll get into the content for today's presentation. So as I mentioned, the first part of the presentation, we're going to provide a high-level overview of some of your tenants' rights. These are your tenants' rights primarily derived from state law, which means most of these rights are going to apply to you as a tenant here in Los Angeles, as much as they apply to a tenant in Oakland or Riverside, anywhere else in the state of California. I'll point out a few specific places where we'll be talking about some local laws that are LA specific, but for the most part, by and large, we're going to be talking about your rights under state law here. Start us off, I want to talk about what forms the basis of your legal relationship with your landlord, and that is your lease agreement. A lease agreement is a contract, and a lease agreement can actually be spoken or written. For a number of reasons, having a written lease agreement is highly preferable. It protects you and it protects the landlord better. But a oral or verbal lease agreement is still an enforceable contract and you still have rights as a tenant, even if you only have a verbal lease. The key terms that you're looking for in a lease agreement is identification of the parties. So who is the landlord and who is the tenant, the premises address, the rent amount, the rent due date, and the start and end date of the lease. If you do not have a copy of your lease agreement and you have a written lease, you can request a copy of this from your landlord. So when you enter into a lease agreement, there's a couple of things that the landlord is actually required to provide to you as part of that contract. And one of those things is that a landlord must provide you with a premises that is considered habitable. Habitable means that the unit is fit to live in and it's in compliance with local health, safety, and building codes. Some examples of common habitability issues is the presence of mold, the presence of pests like roaches, mice, or termites, clogged plumbing, and lack of hot water or no access to heating. If your home is in need of repairs, the first step to take is to provide the landlord with notice of the issue in writing and state what needs to be repaired and give the landlord time to respond. If the landlord doesn't respond or says they're not going to do anything about it, the next thing you can do is complain to your local housing or health department. And in the yellow boxes here, I have the information for contacting the LA City and the LA County housing departments. The other thing that a landlord is required to provide as part of your lease contract is something called the right to quiet enjoyment. And what that means is that you have a right to live in the unit peacefully and use it as you wish, as long as you're not doing something that is illegal and you're not doing something that violates a term of your lease agreement. When the landlord starts to encroach on or violate your quiet enjoyment of the property, that may be considered harassment. In a legal sense, the definition of harassment for landlord-tenant issues is a bit more narrow than how we might think of harassment when we use it in our daily lives. So harassment is acts by a landlord to encourage a tenant to vacate or leave their unit. And state law protects tenants from some types of landlord harassment. So first has to do with what's called self-help eviction. Self-help evictions are illegal in the state of California, meaning it is illegal for a landlord to lock you out, terminate or interrupt utilities, remove doors or windows, or remove your belongings from the unit if they haven't gone through the proper legal channels to try and to evict you from the property. So where the landlord violates this law, you are able to sue for $100 per day that they are in violation. And so this $100 per day might sound a little weird as I describe it now, but this is a helpful thing to understand when we start talking about calculating how much money is owed to you when you're trying to add up the damages that you would ask for in a lawsuit if you decide to file in the small claims court. Other types of protections that tenants have from harassment include that landlords cannot steal, extort, or menace to drive a tenant to vacate the unit. Where the landlord violates this law, the tenant can sue the landlord for $2,000 per violation. Landlords also cannot threaten to disclose your immigration status in order to drive you to vacate the unit. And where the landlord violates this law, again, the tenant can sue the landlord for up to $2,000 per violation. The last protection tenants have from harassment has to do with when the landlord can enter the property and how much notice the landlord needs to give. So I want to give some background on this because there's a lot of gray area here. So generally speaking, landlords need to give 24 hours written notice prior to entry to the unit. There are a couple of important exceptions. So first, there's an exception if the landlord needs to come in to address an emergency. So for example, if your a pipe under your sink is leaking into the apartment below you and causing flooding, the landlord does not need to wait 24 hours to come in and shut off the water to that pipe to stop the flooding. The other exception to the 24-hour rule is if the tenant otherwise provides consent for the landlord to come to the unit. So a common example where this arises is, the property manager or maintenance person may knock on the door and say, hey, I was here working on some other units, or I was in the neighborhood. Do you mind if I come in and look at your smoke detector now while I'm here? If the tenant says, yes, sure, no problem, then they've waived their right to have that 24 hours notice because they consented to the entry to the unit. So landlords can be held legally liable where they are violating or abusing this right to enter the property. And what that can look like is if the landlord is entering the property without any prior notice while the tenant is not home and could not consent to the entry. It can also look like the landlord posting notices to enter the unit regularly, like on a daily basis, where there's no good reason for them to be entering, or it seems like they're just kind of making up a reason to annoy you. So where the landlord's abusing this right of entry, tenants can sue the landlord for up to $2,000 per illegal entry. So this is where I'm going to talk about some of the local laws. Some areas in Los Angeles have additional local ordinances to protect tenants from harassment called tenant anti-harassment ordinances. These ordinances allow tenants to sue their landlord for engaging in additional types of common harassing behaviors and tactics that landlords often engage in to try and get tenants to move out of their units. And these laws also give landlords the ability to sue the landlord for violation of these laws by requesting damages for out-of-pocket costs, levy additional civil penalties, or potentially seek rent reductions or relocation assistance. There's not a blanket tenant anti-harassment ordinance that applies generally to every single person in Los Angeles County. It is split up by localities, so it's important to understand where you live and if you live in a jurisdiction that has these additional tenant anti-harassment protections. So there are tenant anti-harassment ordinances in place to individuals located in unincorporated areas of Los Angeles County, as well as in the following incorporated cities within the county. the city of Los Angeles, the city of Culver City, the city of Long Beach, city of Santa Monica, and city of West Hollywood. The tenant anti-harassment ordinances between each of these localities differs slightly from each one. So I encourage, if you live in any of these areas, to reach out to the different housing departments in these localities to learn more about your rights under the tenant anti-harassment ordinances. And I'll leave this slide up for a moment so folks can take a picture or jot any information down that they might need. The last topic I want to cover in terms of tenants' rights is security deposits. This is a common issue that comes up for folks. A security deposit is something that a landlord can charge a tenant when they move into a unit. They can charge a security deposit to hold on to in case the tenant falls behind on rent or causes damage to the apartment during the course of their tenancy. There are limits on how much of a security deposit can be charged. Currently, as of November 2023, a security deposit can be up to 2 months rent for an unfurnished unit and up to 3 months rent for a furnished unit. A new law did pass in the most recent legislative session that will change this limit. So effective July 1st, 2024, the maximum security deposit that landlords will be able to charge is 1 month's rent. So it's coming down to only 1 month. And this again is effective as of July 1st, 2024. One thing to note is that this law will not be retroactive, so it will not apply to any tenancies starting prior to July 1st, 2024. This is just something to be aware of going forward. The larger issue for security deposits tends to arise after a tenant moves out. So state law sets out a process for how a landlord is supposed to return a tenant's security deposit. It's all outlined under California Civil Code section 1950.5. The law states that after a tenant moves out, the landlord has 21 days to either return the tenant's security deposit in full, or if the landlord wants to keep some or all of the tenant's security deposit, the landlord needs to provide an accounting explaining the reason for the deductions from the deposit and also include receipts or quotes showing how much it costs to make the repairs the landlord is claiming were necessary. So if you do not get all of your deposit back or you don't get any of your deposit back and you believe you're entitled to get that back to you, you may be able to sue the landlord in small claims court to recover your deposit. So I want to give a little more information in terms of what landlords are and are not allowed to charge for from the security deposit. So landlords are allowed to charge tenants for damage caused by the tenant, their co-tenants, or their guests. Landlords also can retain the security deposit to cover any unpaid rent that's due at the time when the tenant moves out. Landlords cannot charge for ordinary wear and tear to the unit. So this is something to watch out for, especially if you were a long-term tenant. You may not always be responsible for things like painting or replacing carpeting if you live somewhere for, 5, 10, or 15 years. And to wrap up our discussion of tenants' rights, I just want to provide some tips for dealing with your landlord. So first off is communicate with your landlord in writing whenever possible. I understand some landlords intentionally make it difficult to communicate with them in writing. So if you find yourself in that situation, a couple of different things you can do is after each phone or in-person interaction, you can send a short email or text to the landlord summarizing the conversation, explaining the date, the time, who you spoke to, and a few sentences of what was said. Or if you prefer a less confrontational approach, you can keep a journal or timeline of events. So keep it in a notebook, keep it in a note on your phone. And again, jot down the date, time, who you spoke to, and a few sentences of what was discussed anytime you have an interaction. The reason that this is really helpful to do is because if you find yourself in a situation where you are planning on going to court and filing a lawsuit, these types of events can be really hard to reconstruct from memory after the fact. So this will save you a lot of time if you already have a written record of all of this down somewhere. Additionally, be sure to take photos or videos whenever possible. So for habitability issues, be sure to take pictures when the issue started, as the issue persists, if it gets worse, anything like that. And same thing with respect to security deposits. Take photos of what the unit looked like when you moved in and take photos of the condition of the unit when you move out, so you have that record to show what condition you left the unit in. And lastly, keep copies of all this information in a safe place. Most people have this on their phones and their email, which is great, but do make sure you have it backed up either, on your phone, to the cloud, to a computer, or you keep a paper file somewhere so that you have backups in case something happens to your phone or your records. Now we're going to move on to a deeper dive into the small claims court process. And so we're going to talk about how you can utilize small claims in particular to sue your landlord when your tenant's rights have been violated. Before I get too deep into the legal process, I first want to preface this by saying that a lawsuit isn't right for everyone, and there are some things you can do to try to avoid going to court. As I've already mentioned, for habitability issues, you can start by filing a complaint with the local housing authority or rent board. And if you feel as though you're being discriminated against, you may first want to try filing a complaint with the California Civil Rights Department. And the link to their complaint process page and to start an online complaint is here at calcivilrights.ca.gov. Mediation can also be a beneficial option for some folks. Mediation is a conversation that is facilitated by a neutral third party to try and resolve a dispute outside of court. Mediation is typically facilitated by a person that is trained in conflict resolution, and they work to help people reach an agreement. Mediation can be really beneficial if the landlord is willing to come to the table. And one of the benefits of mediation is that you can craft much more flexible solutions than you may get from going through the court process, which you'll see in a moment. The court process is very transactional. It's primarily focused just on money. So mediation in some cases may get a more satisfying resolution if you're looking for more than just payment. Additionally, so if you want to move forward with filing a lawsuit, there are different types of lawsuits. You can file a lawsuit in civil court. So civil court lawsuits are divided between limited civil or unlimited civil lawsuits. And the only difference between these is how much money you're asking for in the case. So a limited civil case is a lawsuit where you are suing for under $25,000. And an unlimited civil lawsuit is where you're suing for over $25,000. Another option for filing a lawsuit is to go to small claims court. Small claims court is an expedited and informal court process. The key things to know about small claims court is that there are no attorneys allowed in small claims. So that means you have to represent yourself, and the person you're suing also has to represent themselves. And small claims court has a maximum amount of money that you can sue for. Currently, the maximum small claims amount you can ask for in a case is $10,000. However, effective July 1st, 2024, the small claims limit will increase to $12,500. So that will go into effect again July 1st, 2024. So small claims court, if you have a lawsuit for what is, in the eyes of the court, considered a relatively small amount of money, small claims court can be a much more low cost and efficient way to enforce your rights. A small claims court case from start to finish can typically take about 3 to 6 months, whereas a limited or unlimited civil lawsuit can take a couple of years to get to the very end of the process. And small claims court is much more low cost. The filing fees are much lower than in a limited or unlimited civil suit. And because there are no attorneys allowed in small claims court, there's not going to be as much of an opportunity to rack up attorneys' fees and bills. Now we're going to walk through the small claims court process from start to finish in much more detail. The first thing you'll do before you file anything with the court to start a lawsuit is you need to comply with demand requirement. A demand is an oral or written statement to the person that you want to sue, and the demand states why you want to sue them, the amount of money that they owe you, and how and when you would like to be paid. And here in the box, I have a couple of resources that are really helpful. And both of these resources, the Tenants Together sample letter bank and the Los Angeles Just Fixed letter generator, have templates for a number of landlord tenant issues. So you can use these to help you write a demand letter to send to the landlord with the proper legal citations for your claims. Send a demand letter, you typically wait at least 7 to 14 days to see if you get a response from the person that you want to sue. If they do not respond or they say that they are not a complaint and starting a court case. To start a small claims case, you file a complaint with the court. A complaint is a legal document that states who you are suing, why you are suing them, and what you want the court to do about it. Small claims court uses mandatory forms, and the small claims complaint form is a form SC 100. So the title of the form is the plaintiff's claim in order to go to small claims court. I'm not going to walk through every question of the small claims complaint in this presentation, but I am going to walk through a couple of the more confusing parts of the complaint and give some pointers to help folks be able to get through this part of the process. So the first question I want to address is item 2 on the SC 100. Item 2 asks you to identify who you're suing. So the person you're suing is called the defendant. And in cases where you're dealing with violation of your tenant's rights or an issue with your landlord, the defendant is going to be the property owner or the landlord. If you're dealing with a property manager, then you can also include the property manager or property management company in the lawsuit as well. Finding the landlord is the first thing you need to do. The best place to look to find the landlord is your lease agreement. So way back on one of the first slides, I said the lease agreement should identify the parties, including who is the landlord. So look to your lease agreement and see what name is listed. And then once you locate the name of the landlord, you're going to ask yourself a question. You're going to ask, okay, is this the name of a person or is this the name of an entity? If the landlord is a person, you're looking for names like John Smith, Jane Doe. And when the landlord is a person, you fill out only the top portion of item 2 on the SC 100 form. And you need to put in the landlord's name and you need to put in their address. So finding the landlord's address sometimes can be a little tricky. A couple of things that you can do though. One, again, look at your lease agreement. See if your lease agreement includes the address for an office for the landlord. If there's a place that instructs you to drop off keys, drop off rent checks, that can be a good indicator of a good address to list on the complaint. If you don't have any information like that in your lease and you're not sure what the landlord's address is, a few more things you can do. One is you can do a property search with the LA County Assessor's Office. So they can give you information about other addresses they have on file for contacting the landlord. And there's other resources in this article linked here from the Los Angeles Public Press. It's an article titled Tips and Resources to Find Your Landlord, and it goes through a number of free online resources you can utilize to find an address for your landlord. If you look at the landlord's name and they are an entity, so you're looking at a name that looks like a business name, Landlord LLC, 123 Main Street Incorporated, anything along those lines, then you need to complete the top and bottom portion of item 2 on the small claims complaint. So this bottom portion of item 2 on the complaint is asking you to identify the agent authorized for service of process for the business entity. Every business in the state of California has to register an authorized agent with the California Secretary of State, and that information is available publicly online through the Secretary of State Business Entity search. And so the link to that is here on the slide as well. You can type in the name of the business entity into the search, and once you locate the right name and profile for the entity, you'll be able to see all of the information you need, including the street address and the agent authorized for service process. So this is a screen grab here of what this looks like when you grab it from the Secretary of State website. The small claims complaint only includes space to name one defendant. If you want to do more than one person or entity, you can attach an additional form. The form number is SC100A, and it provides you additional lines to add additional defendants to the case. The next item in the small claims complaint I want to talk about is item 3. Item 3 asks you why you're suing. So it wants to know the purpose of your lawsuit. The language on the complaint specifically says plaintiff claims the defendant owes a certain amount of money. And this is why I was saying earlier that the court process here is extremely transactional and just very focused on monetary compensation. In item 3A, be sure to provide a couple sentence explanation of what happened and why it was wrong, including a summary of key facts with specific names and dates. If you can, state any, provide any state or local laws that the landlord violated. Item 3C also asks you to explain how you calculated the amount of money that you're owed. Be sure to give an exact calculation of the money that you're owed and write it in the top of item 3, right here at the top. And this is where, when I was talking about on some of those harassment protections, how these numbers come into play. So when I was saying that where the landlord locks you out of the property for, say, 6 days, and the landlord is liable for up to $100 in damages per day that you were locked out, then $100 times 6 days is $600. So that's how that weird phrasing in the law comes into play when you're trying to file a legal complaint with the courts. And as you're writing this section of the complaint, make sure that you have evidence to support everything you're saying happened is true, and that supports the amount of money that you're claiming you're owed is accurate. Once the complaint is filled out, you need to take the documents to file with the small claims clerk at the correct courthouse, or you can e-file online. If you're going to file in person, you need to figure out which courthouse is your assigned courthouse. There are about 11 or 12 different courthouses in Los Angeles that have small claims departments, and the correct courthouse is assigned based on zip code. Sometimes the geographically closest courthouse to you may not be your actual assigned courthouse, so it's very important to verify this before you go take documents to file. The LA County Court has an online tool that is called the Superior Court Filing Locator Tool. So you can use this link, input your zip code, and it will tell you which courthouse to go to file your small claims case on the far right of the chart. Once you figured out the right court, take your documents to the courthouse to file with the small claims clerk. And if you would like to have the filing fees waived, complete a fee waiver, and that's form FW001. Once the complaint is filed with the court, you will receive a hearing date. The hearing date will be stamped on the front page of the small claims complaint document. You must plan to go to court on this date. This is the date that you will go to court and present your evidence to the judge. If you cannot make this court date, you need to notify the court immediately. The best way to do this is to fill out and file a form SC-150. It's called a request to postpone. And it's a very simple one-page form where you explain why you can't make it to the hearing date and what date you would prefer the hearing to be scheduled for. You file the complaint with the court and you get your hearing date. The next thing you need to do is serve the documents on the defendant. Service has very specific rules. And service is when the documents you file with the court are formally delivered to the people that you are suing. You are responsible for making sure the defendant is served with the court documents, and there are very specific rules about service that you must follow. There are rules for who can complete service and how service must be done. First, who can complete service? So service must be completed by someone who is 18 years or older, an adult. And an adult who is a disinterested party, meaning someone not involved in the lawsuit. If you are the plaintiff in the suit, so your name is named on the lawsuit as a plaintiff, you cannot serve the documents. It has to be someone that is not part of the lawsuit who is not a plaintiff in the case. There are also rules for how documents can be served. The rules for There are two acceptable methods of service in LA County for small claims court documents. One of those is personal service. Personal service is when the documents are delivered to the defendant in person. And I think an example helps illustrate this here. So say you file a lawsuit in small claims court to sue your former landlord for return of your security deposit. You file the documents with the court, you get your hearing date, and you ask your friend to go serve the documents on your former landlord. Your friend is over the age of 18 and they are not a part of the lawsuit. They're not named as a plaintiff in the case. They go to your former landlord's door, they knock on the door, the landlord answers, and they give the documents to your former landlord. That is proper personal service. The other acceptable type of service is substituted service. Substituted service is when the documents are delivered to an authorized person other than the defendant, and you also send a copy of the documents to the defendant via the mail. To go back to our example, I think this helps illustrate it more. So again, you're suing your former landlord for your security deposit back. You ask your friend to go deliver the documents to your former landlord. Your friend knocks on the door and the landlord's spouse answers the door. The spouse is an example of someone who is authorized to accept the documents on behalf of their partner. So substituted service doesn't allow for you to just hand the documents to any stranger on the street and call it a day. There needs to be some sort of legal relationship between the person who's accepting the documents on behalf of the person you're suing. And then, because you didn't hand the documents directly to the defendant, you also need to mail a copy of the documents to the address you have on record for the defendant. Only sending the court documents by mail is not considered proper service. The court will not send the documents to the person you're suing for you in a small claims case, and you are responsible for making sure service is completed on the person you're suing. Once the documents are served, the person who completed the service can fill out and sign a proof of service and file the proof of service with the court. And, the service part of a small claims case is, I think, one of the most difficult parts. So I have some additional resources here. I especially want to point out that the Los Angeles Sheriff, the Civil Management Bureau, does actually assist with service of process of small claims court documents. So this can be a really helpful alternative to getting your friends or family involved in serving the documents on the landlord, especially if you don't have a good relationship with them. And you can find more information about how to utilize the Civil Management Bureau for service by going to the LA County Sheriff Civil Management Bureau webpage and completing the instruction forms to drop off the documents at the proper sheriff serving office. Additionally, if you would like some more information on finding the landlord and serving court papers, the videos in the yellow boxes here are great resources to hear it explained again by somebody else. These videos are through the LA County Department of Consumer and Business Affairs. The DCBA is the small claims advisor for LA County, and they have a really helpful video library on their webpage where you can get more information on the various steps of the small claims court process. If you file and serve a small claims court complaint, You can then turn to preparing for your small claims court hearing. The main thing you need to prepare for your small claims court hearing is your evidence packet. This is what you'll present to the court in your hearing to support your case. And it's really important that the evidence packet is well organized and easy for you to refer to in the hearing. If you plan to appear remotely in your hearing, you will need to mail all of your evidence to the court and the defendant 10 days before your hearing date, meaning you'll need to prepare this all well in advance of your small claims court hearing. Some tips for preparing your evidence packet. Think about making a book to tell your story. I think of it as a textbook. You want it to be really easy to use and well organized. Some things that are really helpful is one, create a table of contents or index to put on the very top of the evidence packet. This makes it easy to know what is in the packet and on what page each document starts. Then include a copy of each of the items listed in the table of contents in the proper order following the table of contents. It's helpful to label the pages or the different documents clearly, either by assigning them page numbers or putting tabs between each document. And be sure to put your most important evidence first. Small claims judges are very busy and they don't always look at everything put in front of them. If you have something that is really clear cut in terms of evidence that makes a strong case, be sure to put that up front so the judge doesn't miss it. You'll also need to prepare what you want to say in court. You can prepare a written outline, note cards, or script, depending on your comfort with public speaking. And then in terms of what to prepare, you want to plan a summary of what happened that you can explain to the judge in 2 to 5 minutes. Small claims court hearings are really fast and you don't get a lot of time to explain everything. So 2 to 5 minutes is enough that you want to be able to explain to the judge how you were harmed or wronged and what you want the court to do about it. Other tips for preparing for your hearing is as you're getting ready, be prepared that the judge might interrupt you and ask you questions while you're speaking. Try to anticipate some of those questions and make sure you're prepared to answer them. Practice with a family member or friend so that you're not saying all this out loud for the first time when you're getting to court that day. And lastly, you can observe a small claims court session before your hearing. Small claims court hearings are open to the public, so you can go to court any day before your hearing and just observe and get a sense for what the judge is like and what you can expect in your hearing that day. Once you've taken the time to prepare for your hearing, you'll attend your small claims court hearing. The day of your hearing, bring 3 copies of all of your evidence with you. You need to bring a copy of the evidence for yourself, a copy for the judge, and a copy for the defendant. Show up on time or before the time that is stamped on the first page of your small claims complaint and check in with the clerk or bailiff in the courtroom when you arrive. Prior to the hearing beginning, the judge or the clerk may come out and encourage you and the defendant to go out into the hallway and attempt to settle the case. A settlement is an agreement to resolve a legal dispute without court involvement. So prior to your hearing date, be sure to consider if there is a certain amount of money or certain terms that if the landlord offered it, would you be willing to settle the case? So for example, if you're suing your landlord for return of your $3,000 security deposit, if the landlord comes to court and offers you a settlement of $2,000, are you willing to take the guaranteed $2,000, or do you think you have a really strong case for the full $3,000 and you want to take your case to the small claims hearing? Either way, it's completely up to you. Settlement is always 100% your decision, and you are not required to settle the case before the hearing. You're always entitled to have your day in court. When it's time for the hearing to begin, come to the front of the courtroom when your case is called. You will present first because you are the plaintiff, and that's when you start with the 2 to 5 minute summary that you've prepared, and you add details or answer the judge's question as you go. Refer to your evidence packet to support what you're saying as much as you can while you're speaking. Some other tips for presenting your case: speak slowly, address the judge as your honor, do not interrupt the judge, do not interrupt the other party, and do not raise your voice or yell. After your small claims court hearing is over, you will receive a decision. Typically, the judge will not make a decision right in front of you in the hearing. The judge will often take the case under submission meaning they want to consider all of the evidence presented a little bit more, and they will send you their final decision in the mail. So this means you need to keep your mailing address up to date with the court. You can also check your case status by going to the LA County Superior Court website, and they have a case summary page where you can look up the status of your case by inputting your case number into the case status search. The judge's decision about your case is called the judgment. The judgment will say what the defendant is required to do. Usually, if you've won the case, it'll say what amount of money the defendant is required to pay you. If you won the case, the defendant has 30 days from the court's decision to decide if they want to file an appeal or pay you. If the defendant files an appeal, then you will get a notice in the mail of a new hearing date, and you'll need to go back to court and present your evidence again on that date. If after 30 days, you do not receive any notice of appeal and you haven't heard anything else from the court, then the judgment becomes final. At that point, if the defendant has not paid you the judgment, you can move forward with collecting the judgment through certain enforcement actions such as wage garnishment, bank levies, or placing a lien on their property. If you lost the case, the judgment will say that the defendant does not owe you any money. The case is closed and you do not get anything. And you also cannot sue about this issue again. Plaintiffs in small claims have no right of appeal. This means if you lose the case, so you receive a judgment saying that the defendant does not owe you any money, that decision is final and you cannot appeal it. That gets us to the end of the small claims court process and what you can expect if you do move forward with filing a small claims case. In the next couple of slides, I do have a number of different resources, and I just want to point out a couple of them. One is, I've mentioned a few times, is DCBA. They have the Small Claims Advisory Service, and they have a lot of really helpful resources on their website. They have a video library as well as sample forms to help you be able to understand how to fill out some of the court documents. You can access all the small claims court forms for free online through the California Judicial Council website, and the link for that is here. It's located at courts.ca.gov. If you're interested in looking at other resources outside of small claims court, DCBA also runs a mediation program, so you can check that out at their website as well. If you're interested in trying to hire an attorney to represent you in a limited or unlimited civil case, you can look at the LA County Lawyer Referral Service to see about attorneys, see if there's any attorneys that would be interested in taking your case. And also the LA Law Library is an excellent resource for more assistance in these areas. They offer two programs. One is Lawyers in the Library, and one is Ask a Lawyer. And these are programs where they have lawyers that are experts in certain areas of law come in and answer questions, and in some cases provide free legal consultations. These are some resources specifically for tenants' rights and landlord-tenant issues. So the California Tenants' Rights Guide is a really comprehensive guide of your rights as a tenant under California law. The LAFLA Renters Small Claims Project has a library of resources on navigating the small claims court process and has guides on topics such as collecting a judgment and security deposit issues. LAFLA also has a tenant empowerment program that helps support tenants who are experiencing harassment, and more information on that program is on the LAFLA website. And lastly, State House LA, as I already mentioned, is a great resource if you want to attend more workshops to learn about your rights, or if you have received any notice of or summons and complaint for an unlawful detainer action. And again, you can also complete an intake for assistance with the Legal Aid Foundation of Los Angeles by calling our intake number here on the screen, or you can submit an intake online at lafla.org/gethelp. So that's everything we have for today. I want to thank you for joining us.